All right, today's date is May 12th, 2022, and we have one Zoom argument here today, and that is case number 21CA0063-M, Mitchell versus Worley et al. As you can see, the panel is Judge Carr, Judge Sutton, and myself, Judge Teodosio. Each party will have 15 minutes to present their argument. I will be keeping track of time, so Attorney Herron, if you want to reserve time, let me know how much. You can reserve up to 5 minutes, of course. I may interrupt you and let you know as you're getting close to that 5-minute mark, and you can decide if you want to continue or reserve the balance of your time. The arguments, as you both know, are recorded and posted on the YouTube channel. So we always like to say, if you're not arguing, mute yourself and keep your voice up when you are arguing. I can assure you that Judge Sutton, Judge Carr, and I have read the briefs on this case, and we are prepared to proceed. If you are, would you like to reserve some time, Attorney Herron?
Yes, Your Honor, I'd like to reserve 5 minutes.
5 minutes. All right, now I'll let you know, like I said, when you're getting close to that time. Go ahead, you may proceed.
Okay, thank you. Good morning. May it please the court, counsel. My name is Mark Herron. I am counsel for Mr. Mitchell, the appellant in this matter. We have assignments of error in our brief, but it's all really revolves around one core basic issue. Under the facts in this case, pretty much all of which are undisputed, is there some evidence in the record indicating that Mr. Worley's presence in Ohio was initiated, at least in part, the service of his employer's business interests here? And the answer to that question on the first 3 assignments of error is yes, there is enough evidence that there's at least a genuine issue of material fact on that issue. And as for the 4th assignment of error, the answer is yes, and we would say that the evidence is so one-sided that it is in fact Mr. Mitchell that should have gotten summary judgment on this narrow issue, as opposed to Michaels Corporation. The court, I says, read the briefs. The facts are basically pretty much undisputed here. Mr. Worley is an employee of Michaels Corporation. He lives in Missouri. He was brought to Ohio by Michaels to work on this compressor station project in Seville. And his history with Michaels Corporation was that it frequently sent him out of state to work on these types of construction projects involved in something having to do with pipelines. I don't know all the technology behind it, but he had been sent to places like Tennessee, South Dakota, Minnesota, which is where he actually gave his deposition in this case, Ohio, and I think a few other places, because of his expertise in this particular type of project. And as Mr. Worley put it in his deposition, they brought him here because they knew him, because the company knew him. And as the company admitted in its deposition, they brought him here because it was good for their corporate culture to have someone with Mr. Worley's level of experience working these projects for it. And that is what brought him to Ohio when this accident occurred, when he ran over Mr. Mitchell in Wadsworth when he was turning onto the freeway to go to work. When you look at the Osborne case, it has a Supreme Court case which defines what course and scope of employment is. All it requires is that it be initiated, at least in part, to further or support the master's business. And the admissions that Mr. Worley has made, the admissions that Michaels made at its deposition, show that this wasn't just initiated in part to serve its business. He was here to work for it until the project was done, as he had done in many other states for them over the course of his employment with them. And we submit that that is enough to create at least a genuine issue of material fact, triable by a jury, on the course and scope issue, but that because there's absolutely no evidence in the record refuting any of this, and these are all of the defendant's admissions upon which this evidence is based, is that it is Mr. Mitchell who is entitled to summary judgment on the course and scope, the vicarious liability issue, not Michaels Corporation. Michael's arguments in this case have been based upon several errors, erroneous precepts, and in some cases, I think just an outright ignoring or misrepresentation of the facts. Their basic claim, and they they weave this through and out throughout their brief, is that Mr. Worley was residing in Ohio at the time that Mr. Worley moved to Ohio to work this job. Linguistics aside, that simply is not what the facts are. That simply is what the parties testified to during their depositions. That's simply not what the evidence is. We have cited in our reply brief a decision from the Ohio Supreme Court's tax case, not a respondent superior case, but it's a tax case that discusses what the courts are to look at to determine whether somebody has changed their domicile. And
Nope, I'm going to stop him. Can you hear me, Attorney Heron? Because you're froze. Is he froze on
Yes,
your screens as well,
Yes.
judges?
yes, he is.
All
the
right.
argument is going to be that
Oh,
Mr. Worley,
okay. Excuse me. You froze up at about 10:39, Attorney Heron. So we missed a couple minutes of your argument. I stopped the timer for you, but
what was
I
the
don't know.
last thing you heard me say? I can pick up.
About the Supreme Court case in the domicile. That's the last thing I heard.
Right. And the court said the basic test on that is, what is the individual's intent? Is it what does he do or she do to indicate her intent to reestablish or to establish domicile in Ohio? And there's absolutely nothing in the record that indicates that Mr. Worley ever intended to relocate and permanently live in Ohio. Number one, he went back to Missouri when the job was done. And number two, and we cited, he never didn't sell his home in Missouri and buy a home in Ohio. He didn't relocate his family. He didn't register to vote here. He didn't get a driver's license here. It doesn't look like he's ever paid taxes here as a resident. The burden would have been on Michael's corporation to show through summary judgment that there would be no genuine issue of material fact. They would have to come forward with facts indicating that Mr. Worley intended to relocate to Ohio, to change his legal domicile from Missouri to Ohio. And they put forth no such evidence. And based upon that and the fact that Mr. Worley moved back to Missouri when this case, or when the pipeline project was done, undercuts their arguments that he resided in Ohio at the time of this accident. It undercuts their arguments that he relocated to Ohio. He never relocated here. He came, he did the project, took about a year. He was here as long as the company required him to be here. When it was over, he went back, picked up a new project. In fact, when he gave his deposition in this case, he was working another project in Minnesota. So, that undercuts a significant part of Michael's argument in this matter regarding, whether he was an Ohio resident or not. He wasn't. And the second false premise upon which Michael's bases its arguments in this case is that travel was not an essential part of Mr. Worley's job with Michael's. And travel was pretty much the main part of his job, because all of the assignments that he worked at for Michael's, none of them were in Missouri. They were in the Dakotas. They were here in Ohio. I think they were in Tennessee. They were in Minnesota at one point or another. He was an employee who was dispatched out from site to site to site to site to do whatever Michael's corporation needed him to do with regards to what it does in helping build these gas pipelines. That was his job. He didn't work from home. He worked wherever they sent him to.
of course, he was working at a fixed job site though, wasn't he?
Well, in a matter of layman's terms, yes, the compressor station site in Seville was not moving around from place to place. But the job sites that Mr. Worley was assigned to were not, in the more legal sense, fixed job sites near his home in Missouri. They were job sites wherever the company had contracts to engage in these construction projects. And when they told him to go there, he went.
Mm-hmm. You're not suggesting that any out-of-state employee is automatically within the scope of employment when they come to Ohio and start working a job, are you?
Well, if they're sent to Ohio to work a job, whatever job it is, then as long as they're in Ohio performing that job, yes.
You would say that would
That's
be,
the situation that we had in the Marsden case, and there was another case, I forget the name of it off the top of my head. One case involved a employee sent to California who was in an accident on his way back from dinner after his job had concluded. He was still found to be in the course and scope of his employment for workers' comp purposes. And then the case where the employees had been sent to Michigan and were woken up by a fight in the middle of the night and got injured during that, they were still found to be course and scope of the employment. And none of them were working. One was coming back from dinner and the other was sound asleep, but that was still course and scope because the employer had sent them there. And as the court said, that as long as they were there, so long as they were not off on a clear personal detour, that they were in the course and scope of their employment.
Counsel, let me interrupt you just for a second. Sure. I'm still confused, I guess, in regard to, it sounds like you're arguing under workers' comp law, but then you say, you know, it applies even if it's not workers' comp cases. But I'm not sure, it seems like almost everything you argue is workers' comp.
Well, and that's the case laws, and the company argued this in its or pointed this out in its original summary judgment motion, that the courts in responding to superior cases like this one, workers' comp cases like some of the ones that I've cited, the legal principles are interchangeable and the terms do get juxtaposed around, and I can see where that leads to some confusion. But even in the workers' compensation context, they're still looking at the same broad issue. Was the master's business relationship being served by what the employee's conduct was at the time? And I think it's the Kersenik case that I cited, it's out of Cuyahoga, which was not a workers' comp case, acknowledged that, yeah, the terminology and the issues are somewhat the same, even though there's two different contexts, workers' comp versus non-workers' comp. I think one of the ironies, and this goes to your point, Judge Carr, is, and thank God Mr. Worley wasn't injured in this, but under the case law that we've cited, had he been injured in this accident, he would have been entitled to recover workers' compensation benefits because it would be considered course and scope of his employment, even though because he was a traveling employee under the workers' comp lingo.
Attorney Herron, you're a little below your 5-minute rebuttal time. Do you want to continue, or?
I'll just finish up my point and then end it at that.
All right.
It would be, the legal term outrageous, I think, is what comes to mind, for if Mr. Worley had been injured to be able to recover workers' compensation benefits, but for the real victim here, Mr. Mitchell, to not be able to recover from the employer for his injuries. And with my time running out, I will rest at that and ask that the court reverse the decision of the court below.
All right, you'll have 4 minutes and 15 seconds for your rebuttal.
Thank you.
Attorney Wilson.
Good morning. May it please the court, counsel. My name is Holly Marie Wilson, and I'm here today on behalf of the appellee Michaels Corporation, arguing in favor of the trial court's grant of summary judgment below. To be clear, plaintiff's proposition seeks to obliterate the coming and going rule for every out-of-state employee. Mr. Worley was not sent by Michaels to Ohio. Mr. Worley was recruited for a position in Ohio. He applied for that position. He got the position. He moved here temporarily to complete a job. He was here for over a year. When that job was completed, he went home. For the entirety of his time in Ohio, Mr. Worley worked at a fixed location. He reported for work every morning at 7 a.m. He was not paid for his gas. He was not paid for his travel time. He was not paid to come and go anywhere. He showed up for work, he clocked in. When he was done for the day, he clocked out. When the contract ended, as Mr. Worley knew it would, he was no longer employed by Michaels. At different points in time, Michaels has recruited him. Would you work for us on this project? And it's up to Mr. Worley to say yes or no. So he's not a full-time Michaels employee who's sent from place to place to place. That's just not how this situation worked. And that's made clear in the record by Mr. Worley's own deposition testimony. Under these facts, he's a fixed situs employee, as that is defined by Ohio law, and he's coming and going from his job at the time of the accident. Employers are not liable for accidents or for the actions of their employees when that employee is commuting to and from work. Again, black letter law. Now here, plaintiff seeks to create liability where none exists by invoking the special benefit and the traveling employee doctrines as exceptions to the coming and going rule. The trial court properly rejected those exceptions in its grant of summary judgment. As to the special benefit, as I mentioned earlier, yes, Mr. Worley was a good employee, and yes, Michaels recruited him for this specific job in Ohio. But that is no different than any other employee who recruits the most talented workers it can find. And it certainly does not create liability for that employer while the employee is outside the course and scope. Mr. Worley, at the time of the accident, was using his own personal vehicle, and his workday had not yet commenced. He was not paid gas or mileage. He didn't transport tools or other employees from Michaels from one site to another. So this is dissimilar from the cases cited by plaintiff where an employee checks in at the employer's headquarters, gets an assignment for the day, and then drives someplace else to do the work for the day.
Attorney Wilson, was the employee, was he paid a per diem? And if so, were the other locally hired employees paid a per diem as well?
He was paid a per diem, yes, ma'am. Anyone who did not live within 50 miles of the job site, Ohio's a big state, there's lots of other employees, Ohio employees who are outside that 50-mile mark who are paid the per diem.
Thank you.
Because there was no special benefit to Michaels, other than the fact that Mr. Worley was a great employee and they wanted to have him, just like all the other great employees that Michaels assembled for this team, that is not enough to reach that high threshold of special benefit, as that term's defined in the case law.
Counsel, can we back up a minute in regard to the question that Judge Sutton asked you about the per diem and so forth? And you said because he lived outside the 50-mile mark, therefore he got paid a per diem. Doesn't that kind of undercut your argument that he was at a fixed site and therefore the coming and going rule applies?
Well, the fixed site is in the case law defined as where does the day-to-day job take that person? And here we have fixed situs because day to day, Mr. Worley reported to the exact same location. It wasn't Ohio one day, Michigan the next, Tennessee 2 weeks later. It was for the entirety of this project, you report to Ohio. And when
right, but you paid, excuse me, I'm so sorry, but you were paying him as though he was driving from Ohio. I mean, from his permanent residency, because he wasn't traveling over 50 miles on the day of the incident, right? He was just right around the corner, basically 10 minutes, I think, away or something like that, they said.
Yeah, 12 miles. It is in appreciation of the fact that when employees have to travel or commute long distances, it poses extra financial burdens on that employee. So anyone who's outside a 50-mile radius of the job site is paid this per diem. And when we look at the case law, we have employees who are receiving a per diem who are still not deemed to be providing a special benefit to the employer. And again, when this project in Ohio ended, so too did Mr. Worley's employment. When you look at his deposition transcript, he worked for other companies in between working for Michaels. We next look at the traveling employee exception. And this in particular is a creation and a creature of workers' compensation law. It is exclusively applied in the workers' compensation context. It has never been applied to expand liability in a respondeat superior case. The traveling employee is one who travels away from their employer's premises, not their own personal residences. So just because you're traveling from your home doesn't mean you're a traveling employee. You have to travel from the employer's premises. In this instance, the employer's premises was Michael's project in Ohio. That was the fixed situs. That's where Mr. Worley went to work every single day. It was a fixed job site. When we look at the cases actually cited by plaintiff, we can set aside, we shouldn't, but even if we set aside the fact that these are exclusively workers' compensation cases, we also see that these are all employees who are required to travel as part of their day-to-day work. Mr. Worley did not travel as part of his day-to-day work. He went to one place every single day and came back to where he was staying, the hotel in that place. You know, we live in a society today where employees often travel for work. They take full-time temporary assignments. When that assignment concludes, they go home. Every single out-of-state worker who comes to Ohio for a job is not automatically entitled to respondeat superior liability. Employers just simply don't take on that level of potential liability just because they retain someone who lives in a different state. It goes well beyond any law that we have right now. And it would require this court to take a significant departure and indeed create an entirely new category of liability for employers. The trial court correctly applied the law to the facts and ruled in favor of Michaels by denying plaintiff's cross motion for summary judgment, granting Michaels' summary judgment motion. For all the reasons that we discussed and for all the reasons in the brief, we ask that that decision be affirmed. If there are no further questions, I'm happy to concede my remaining time.
All right, thank you, Attorney Wilson. Let me check with Judge Sutton. Any questions for Attorney Wilson?
Oh,
Judge
thank
Carr,
you.
anything further?
No, thank you.
All right, thank you for that argument. That takes us back to Attorney Heron, and you will have 4 minutes and 15 seconds left for rebuttal, sir. You're muted. You're still muted. I'm sorry. Okay, let's try that. There we go.
All right. Thank you, Your Honor. I want to pick up on a point that Ms. Wilson was trying to make regarding what liability or exposure employers take on when they bring employees in from out of state to do jobs for them. And under the respondeat superior context, as the Ohio Supreme Court stated in the Osborne case, they undertake that responsibility, they undertake that risk of liability when they bring somebody in and their actions are initiated even in part to further or support the master's business, the employer's business. I don't like that term master, but the employer's business. And that is exactly what happened here. And we haven't heard anything to refute that. They recruited Mr. Worley, the confidential that is, or Michaels rather, recruited Mr. Worley to come to Ohio to work on a compression station project in Seville, Ohio for it. They brought him here because they wanted to use Ms. Wilson's terms, the most talented employees. That's a benefit to Michaels Corporation. They wanted him here according to their own deposition testimony because it was good for their corporate culture to have employees with his level of experience. That is initiated even in part, at least in part, to further support Michaels' business. As Mr. Worley put it, they wanted him here because they knew him. That's initiated even in part to support Michaels' business. And the evidence is simply very clear. It's unrefuted. There is absolutely no, we can parse the linguistics all we want. The facts are the facts. And that is why he was brought here. And that is why he stayed here and worked this job. They wanted him here. They wanted his talent. They brought him here. That's sufficient under Osborne and under the other case law to establish the potential for respondent superior liability in this case. Now, contrary to what counsel said, I want to pick up, I think it was Judge Carr you had asked about the per diem. And the per diem was to assist Mr. Worley with his lodging expenses, his meal expenses, his gas expenses while he was in Ohio. They don't give that to everybody. 50 miles was the range. But if you look at it from a practical level, Steelville, Missouri, which is somewhere near St. Louis, that's not an easy commute to Seville on a day-to-day basis. He's going to have to stay here, absolutely. And that's what that per diem was for. And you don't get that if you're local. And that, again, is an inducement, a carrot to a person in Mr. Worley's position to come take this job. There is nothing I don't see anything in the record about Mr. Worley having other employment between jobs with Michaels Corporation. The way I've explained during the deposition was that when they need him at a site, they send him there. He can't work in Missouri. The Michaels Corporation itself is based in Wisconsin, somewhere in the Milwaukee area. So it's not like he can just drive from home to the office, which is what the traditional coming and going rule applies to. I see I'm about out of my time. Unless the panel has any other questions, we will rest on our arguments and ask that this court, at a minimum, overturn the summary judgment ruling on this issue and allow it to be tried. But we again submit that the facts are really so one-sided on this issue that it was Mr. Mitchell and not the company that was entitled to summary judgment in this case.
Judge Sutton, any questions for counsel? Judge Carr?
No, thank you.
All right. I want to thank you both for providing the court with excellent arguments. We're going to take the matter under advisement, as we usually do, and issue a decision in due course. The clerk of courts will mail each of you a copy of the decision on the day it's released. And as you both probably know, the opinions are also posted on the Supreme Court of Ohio's website.